Hi and welcome back to the channel. Today we are launching a new lecture series on the channel where we talk about topics which are geared towards students who are studying for their law exams. And today's conversation will be around equity and trust law. Now, this will be an ongoing series where I will discuss different aspects of equity and trust law over the next few weeks. Today, we're going to focus on an introduction to equity and trust law. Now, just to give you a little background, I have been teaching equity and trust law for the University of London degree program for over 10 years. And in that time, I've identified some of the pain points that students face. So hopefully we can address them throughout the course. So let's get started. First of all, what is a trust? A trust is a little bit difficult for students to understand because it's not something that they come across in their day-to-day. Now, let's take a contract. A contract is between two parties, and one party provides services and the other party provides money for that. It's between the two parties who are bound by that obligation. A trust is a relationship which has a third party involved, a person who has been trusted with something to carry out something for someone else. Let me break this down. Say, for example, X wants to give Z some money. Now, X can directly give that money to Z. That would be very straightforward, where it would be a transfer from X to Z. But instead, X could also give that money to Y and ask Y to hold it on trust for Z. So, the property is given by X to Y, and then Y holds it on trust for Z. Now, this is a trust, and Y is your trustee. We call X the settlor and Z the beneficiary. What is the subject matter of trust? The subject matter is the property that is being given by X to Y to hold on trust. This could be personal or proprietary. So that means I can give a property to Y, let's say a land, to hold on trust for Z. I can give Y some money to hold on trust for Z. I can give Y some shares to hold on trust for Z. I can even give Y a right that I have, which Y has to then hold for Z. Now, the next question that arises is, why would you create such a trust? Because when you can transfer the property directly from X to Z, why would you bring a third party in? Well, there are multiple reasons why you would want to create a trust. The number one reason is flexibility. Because when you give the property to Y to hold on Z, you can control when Z gets the property. Say, for example, if Z is a minor, you can give the property to Y and say, hold this property until Z is of age. Or you can give it subject to a condition. Say, for example, you say that Y is to give the property to Z when Z finds a job. And sometimes you create a trust because the beneficiary is incapable of holding the property. Sometimes it's because they are minor, someone who is of unsound mind, and therefore they can't hold the property, they don't have the capacity to hold the property, so you give the property to Y to hold it for Z. And finally, when you create a trust, you can split the enjoyment of that property between multiple parties. Think about it. If I give a property to my son, then if I transfer it directly to him, then he is the beneficiary, nobody else can benefit from that property. But if I give the property to a trustee and say, my wife gets to enjoy this property during her lifetime, and upon her death, my son gets the property. That way, there are two people who are able to enjoy the property during the course of their lifetime. Okay, so now what is the legal basis? What is the judicial effect of creating a trust? So we have to look at who owns the property. How does ownership change when you create a trust? Now, let's take a baseline. If A transfers a property directly to B, then the legal title that A has will transfer to B. Very simple, right? Now, along with this legal title is the beneficial interest in that property. That beneficial interest also transfers to B. Now let's take a trust situation, a slightly different situation. If A transfers property to C to hold on trust for B. So we say hold on trust for B. Let's say it was £1,000. Now, how does the title pass? A started off with the legal title and the beneficial interest. The law will say that legal title passes to C when you transfer the property. Now, here's where equity kicks in. Equity says the moment A transfers the property to C to hold on trust for B, a new right is created in the name of B, and that right is an equitable interest. We call it an equitable interest. An equitable interest is a new right that is born in favor of the beneficiary the moment the trust is created. What does this equitable interest allow the beneficiary to do? The beneficiary is able to hold the trustee to his trust obligation. Meaning, if the trustee doesn't do what he's supposed to do under the trust, say for example, he's supposed to hold it for the beneficiary, B, but if he starts to use that £1,000 for his personal use, then B can sue C for breach of trust. That's a right that is being given to the beneficiary. So what the beneficiary has is the power to go to court and enforce his trust obligation. That arises from the equitable interest that he's being given. Similarly, he also has the right to benefit from the trust. That is also part of the equitable interest, right? Although this beneficial interest of the title is with C, C is suspended from using it. Think about it like this. Let's say A transfers a coconut estate to C. Now, there is a harvest in the coconut estate, which comes in every year, which is sold and money comes in. Now, C is supposed to hold all of this, that is the land and the income from the harvest, for B. Now, if C starts to use the income from the harvest for his personal use, then B can stop him from doing so. He can stop him using his equitable interest. But of course, if the trust instrument says that C can keep the harvest income for his personal expenses, then there's nothing wrong with it. That is, if the trust instrument says that the trustee can use the harvest income for his personal use, then the trustee, C, is not just a trustee but a beneficiary as well. But that's getting a little ahead of ourselves, so let's leave that for the moment. So what's key to understand here is that trust is an equitable instrument. It's an instrument that is only seen in equity. Now, if you don't know a lot about equity, well, equity is another stream of law that exists parallel to common law. It was initially created as a means of mitigating the harshness of common law in England. So the common law courts would decide cases, but if they followed the letter of the law a little too harshly, the litigants could go to the equity courts, and equity will look at doing justice, will look at the grievances of the parties and try to do justice. That was the objective of equity. But now, equity and common law are administered by the same court. So, if you really think about it, a trust instrument is only seen by a judge when he puts on his equity glasses. Imagine it's a pair of 3D glasses where when he puts it on, he sees this equitable relationship. When he takes them off, he only sees the common law relationship. So, to take our example again, if a judge looks at this relationship from the eyes of common law alone, he will only see this part. A has transferred £1,000 to C. That's all he will see. But when he puts on his equity glasses, he will see this third person and this relationship. This part will become clear to him. Okay, now the next thing you need to know is that there are different types of trusts. And throughout this course, we will be discussing each of these different types of trusts in different lessons. Now, Let's break this down. Trusts can be broken down into express trust versus trust by operation of law. Express trusts are trusts which the settlor intentionally creates. He expressly says, or he expressly writes down, that he is transferring property to X to hold on trust for Y. It's expressly created. A trust by operation of law is where the parties didn't expressly say there's a trust relationship, but the courts interpret that situation as a trust relationship. A good example of this was Chase Manhattan Bank versus Israel British Bank. In this case, one bank made a mistaken payment to another bank, and the courts held that the party that made the mistaken payment was transferring this property to the other bank by mistake, and therefore there was a trust relationship. The bank that received the money was holding the money back for the party that made the mistake on a trust that arises by operation of law. Now, here the parties didn't intend to create a trust, but the courts interpreted that there was a trust. Now, express trusts are then broken down into two parts: fixed trusts and discretionary trusts. What are fixed trusts versus discretionary trusts? Now, a fixed trust is a trust where the settlor has fixed every aspect of that trust. Let's say, for example, a husband creates a trust by which he transfers his land to a trustee to hold on trust for the wife during her lifetime, and after that for the children. Now here it's very clear how the trust instrument is to be carried out. The wife is supposed to enjoy the property during her lifetime, and upon her death, the children are supposed to get it. Very clear, nothing for the trustee to decide. The trustee simply has to carry out the instructions given to him. Now, on the other hand, a discretionary trust is where certain elements are left at the discretion of the trustee. Say, for example, I transfer £10,000 to my trustee and say to distribute it amongst my children as my trustee thinks fit. This way, the trustee can decide how much each child gets. If I have 3 children, he can give it equally, or the trustee can give 50% to child A and 25% to child B and C. In any way that the trustee wants, the trustee can exercise their discretion. That's a discretionary trust where the trustee has been given the power to decide how to distribute the property. And then there is a third express trust, which we call bare trusts. Bare trusts are simply trusts where the trustee is holding the property at the instructions of the beneficiary. There are no terms to that trust. The trustee is simply holding it for the beneficiary. When the beneficiary says, give me the money, the trustee gives the money. There is no terms attached to that trust. Then we'll look at trusts by operation of law. Trust by operation of law has different types of trusts. Number 1, you can have resulting trusts. Resulting trusts are trusts where the trustee tries to exercise his trust obligation, but for some reason cannot do so. Let's say the trustee is told to give 10,000 to my best friend A. Now when the trustee looks for A can't be found. A is not around. A is dead. So then what happens to the property? Equity says that the trustee cannot keep the property because that would be unjust enrichment. So the trustee will return the property on a resulting trust back to the settlor. So it looks a little bit like this. If the settlor gives some property to the trustee to hold for the beneficiary, but for some reason you cannot give it to the beneficiary, then the trustee will return the property on a resulting trust for the settlor. Of course, there are different varieties of resulting trust, which we will have to talk about later on when we discuss resulting trust separately. Other major category of trust by operation of law is constructive trust. Constructive trust. Constructive trusts are trusts which are created by the courts. The courts interpret the situation as a trust relationship. Like in the case of Chase Manhattan Bank, when a mistaken payment arose, the courts interpreted that situation as giving rise to a trust. That's a constructive trust. Finally, there is another category here, which is called implied trust. But if you read any of the major textbooks on trust law, they don't spend a lot of time on implied trust because it's a bit of a mixed bag of different types of trusts. Implied trusts are essentially trusts that are implied. The parties don't intend to create these trusts, but they are implied by operation of law. Not necessarily by the courts, but by operation of law. And finally, there is another subcategory of express trusts, which are called purpose trusts. Purpose trusts. Purpose trusts are trusts which are created for a purpose. Now, if you were to expand upon this a little bit more, usually a trust looks like this. There is a beneficiary who benefits from the trust, who has the equitable interest to enforce that trust obligation. Now, a purpose trust is a trust which is created for a purpose. There is no beneficiary, no specific beneficiary rather, but there is a purpose for which that trust is created. A good example of this is where I leave £1 million to feed the poor. This does not have specific named beneficiaries. There are people who will benefit from it, but there are no beneficiaries. This would qualify as a purpose trust. Now, the courts don't like purpose trusts. The courts generally say purpose trusts are invalid. Can you think of why? It's because purpose trusts don't have anybody who can enforce that trust obligation. There is nobody who can enforce a trust obligation. Because of that, purpose trusts are considered to be invalid. However, it's not that simple. There are two types of purpose trusts that exist. Charitable purpose trusts and non-charitable purpose trusts. Charitable purpose trusts are trusts which are considered to be beneficial to the public at large, which are recognized by statute or by common law. Now, for example, in England, the charitable trusts are recognized by the Charities Act of 2011. So, statute overrules this principle that says purpose trusts are invalid and says charitable purpose trusts are valid. That means, by default, non-charitable purpose trusts are usually invalid in the eyes of the law. But again, there is a small subset of non-charitable purpose trusts that are tolerated by the courts. Again, we will discuss this when we talk about purpose trusts as a lesson. Anyway, that's it for this episode. So hope you understood the fundamentals of what a trust is. What we talked about today is number one, what is a trust? We talked about how a trust is where property is given to a third party to hold for the beneficiary. Instead of giving it directly to the beneficiary, you get the third party to hold it for the beneficiary. And then second, we talked about what are the rights and how does the beneficiary get rights under the trust. We talked about this idea of an equitable interest being created in the name of the beneficiary. And then we talked about the different types of trust that exist. We talked about express trust and trust by operation of law. And then we talked about the different variations that exist. Anyway, that's it for this episode. Hope you found this useful. What we will do is we'll continue this lecture series every week where I will discuss a different aspect of equity and trust law in each session, which will help you study for your equity and trust exams. If you like this video, please do consider liking the video and subscribing to the channel, and do share it with anybody who might find value in this. I'll see you in the next one. Take care. Bye.